Supplementary list, item number 1.
Wait, please, Your Lordship. Lordship, this is a bail seeking pre-arrest application seeking pre-arrest bail. But Your Lordship will find the FIR at.
Yeah, Lordship, before we start, Lordship, I would like to point out one thing, Lordship. The petitioner has directly approached the High Court, Lordship, without first approaching the Session Court, Lordship. There is one order passed by the Supreme Court, Lordship. Lordship may examine this order.
There are various judgments, my lord, which really does not put embargo on directly moving the High Court.
This order was passed on this week 9.
There is no
There's no bar, my lord, per se.
no bar,
Yes,
but
there's no bar.
in the light of what has been observed by the Supreme Court,
Lordship,
I think this relates
may
to
examine this
that
order.
Kerala case, isn't it?
Yes, yes, Lordship.
My lord, we can have it tomorrow, my lord. I'll go through this judgment. Let him supply a copy of this. I'll try and satisfy why this honorable court can take up directly.
On preliminary grounds, there is Thapal and counsel for the petitioner. This is matter tomorrow.
Problem.
Item number 2.
This is for admission of the appeal.
Lordship, only on the stay, Your Lordship, of the proceedings. Stay of the proceedings, execution proceedings.
Once appeal is in place,
Appeal is already on board.
execution should be.
I would like to please the law. What is the law under Order 41 Rule 5? I'll read that, Your Lordship may.
Yes.
Here, Your Lordship, the applicant has filed an application under Order 41, Rule 5 of CPC, for stay of the judgment and decree passed in the.
Yes.
Your Lordship. Your Lordship, I would just like to place the bullet points for. Your Lordship, I would like to take Your Lordship to the CPC, Order 41, Rule 5.
Yes.
I'll read, Your Lordship. Rule 5. Stay by the appellate court. An appeal shall not operate as a stay of proceedings under decree or order appeal from, except so far as the appellate court may order, nor shall execute a decree be stayed by reason only of an appeal being preferred from the decree. But the appellate court may, for sufficient cause, order stay of the execution of such a decree. My humble submission, Your Lordship, there is no sufficient cause made out by the party herein for stay of the execution. That's one, Your Lordship. Now, Your Lordship, 5.2. Stay by court which pass the decree. When application is made for stay of execution of an appealable decree before the expiration of the time allowed for appealing therefrom, the court which passed the decree may, on sufficient cause being shown, order the execution to be stayed. Now here, Your Lordship, even in 5.2 also, the judgment was passed way back in 2020. there's no sufficient cause made out in the application. It's beyond the limitation period. And 3, Your Lordship, no order for stay execution shall be made under sub-rule 1 or sub-rule 2 unless the court making it is satisfied. Substantial loss may result to the party applying for stay of execution unless the order is made, that the application has been made without unreasonable delay, and the security has been given by the applicant for due performance of such decree or order as may be untimely be binding upon him. Subject to the provisions of sub-rule 3, the court may make an ex parte order for stay of execution pending hearing of the application. 5. Notwithstanding anything contained in the foregoing sub-rules where the appellant failed to make the deposit or furnish the security specified under sub-rule 3 of rule 1, the court shall not make any order staying of the execution of the decree, Lordship. Yeah, Your Lordship, they have to make a deposit also, Your Lordship, if a stay has to be applied before this court. That also has not been done. They have generally applied Order 41 Rule 5 without any sufficient cause being made out, without compliance to all the provisions under Order under 41 Rule 5, 1, 2, 3 and 4.
Yes.
So I have submitted a brief note, Your Lordship. And secondly, Your Lordship, can we have the prayer in the execution case? Page 8, Your Lordship.
8, sir.
Page 8 of the stay application filed by my learned friend. Number 12. This case number 12.
Yeah.
Here, Your Lordship, in the premises aforesaid, it is humbly prayed that Your Lordship may graciously be pleased to admit this stay petition. Upon hearing the parties, be pleased to grant the following relief. To stay the impugned order dated 11/3/2020, passed by the Honorable Special Judicial Officer in LA Case 108/2015 and 29/5/2025 in execution case number 1 of 25. Now, Your Lordship, Order 11/3/2020 was passed way back in the year 2020. In this particular application, there's no sufficient cause been made out. What is the unreasonable delay in filing the appeal and the stay? Even in the stay application, there's no sufficient cause made out. And secondly, the second prayer, 29/5/2025. This is, they're asking for the stay of this order. This particular order, Your Lordship, has already been superseded by order dated 16/6/2025, whereby they have conceded before the trial court that they'll make the deposit within 10 days. So in my humble submission, Your Lordship, the prayer made for stay of the order 29/5/2025 is redundant, Your Lordship, because this particular order has already been superseded by 16th, whereby they have prayed for time to make the deposit. And thirdly, Your Lordship, they participated in the proceedings before the trial court, before the execution court. They participated, and there were orders passed by the court for compliance, which they have agreed. Now they cannot take a U-turn and come and file an appeal again.
May please.
And they have made a concession also. I pointed out, that's why I have submitted those points, Your Lordship, just to point out before the court what is the conduct before the execution court. After they have conceded, participated, now they take a U-turn and say something else. Now they have an alternative remedy also, Your Lordship. If the matter is pending before the execution court, there is a provision which provides to stay the execution. Now, after taking a U-turn before the execution court, now we've come before this court, making an application for stay. That too, Your Lordship, by suppression of material facts and by not following the due process. And number 3, by not even making any kind of deposit as mandatory under Order 41, Rule 54 of CPC, Your Lordship. A deposit has to be made if ST has to be granted by this court.
What would be the quantum?
I'm not mistaken, Your Lordship, is 50%. 50% of the decretal amount.
By way of bank guarantee?
The entire amount, Your Lordship,
Should it be by way of bank guarantee or?
by bank guarantee.
Yes, miss, what do you?
Lordship, unless the case comes for admission, where on last occasion we were on condonation of delay, Lordship. Unless the delay is condoned, we are to file, the appeal is not admitted or Honorable Court has not directed us to pay the amount, we are not in a position to pay the amount, number one. Number two, sufficient cause regarding what my learned friend has raised repeatedly is already been, this Honorable Court has already passed an order on the sufficient cost which has been made out and condoning the delay, Lordship. Now, Lordship.
You see, sufficient cause only with regard to condonation of
Condonation of delay.
but
Yes,
not sufficient cause for stay of the execution.
Lordship.
Two different things.
Lordship.
That you have to clarify.
Lordship. Now, Lordship, when on scrutinizing of record, when I have also placed that in my petition, that on scrutinizing of record, when we found that award is not there, and repeatedly, Lordship, in my annexures, also in my stay of executions, I have also enclosed, Lordship. We have, that is why, Lordship, I am also pressing that let the records be called for, because I have filed a show cause also there stating that there are the decree holder is the claimant is different person, decree holder is different person, and execution is different. The petition filed by executant is different person. So we have filed an petition regarding raising of this confusion. Subsequently, they came up with an affidavit stating that they are the directors. Now, Lordship, when on repeated prayer, what we have made before the learned judicial officers, that if the matter taking, as we are the beneficiary, we need to release the amount. So, if we are not aware who is the person, because the company is a different identity than the director. If in the Lordship, the award which has been placed by my learned friend before the other case, where I'll just supply the copy. Here in the award, it is reflected in number 29, serial number 29 as Radha Creations. So, Your Honor, judgment, the decree holder is of different identity person, though maybe he a director, but he is of different identity person. They have never raised that concern and never rectified the judgment, Lordship. Now, when in the execution proceedings, when we have raised all those objections, they came up with an affidavit stating that on expiry of the one of the director, the subsequent director is the son and has stepped in the shoes of the father. But whether the judgment has been rectified, Lordship? No, Lordship. The judgment has not been rectified. So whether there is an execution, can the execution be made out, Lordship? How can the execution be made out? Because, Lordship, it is already in a two different identity, Lordship.
See, Miss, I think all your contention would be relevant before the execution court. You have to raise all these issues.
I have raised, Lordship.
And you see, you may have raised whether any effective order has been passed.
It has been passed, Your Lordship.
And if any order has been passed in that regard, detailing all your concern or your contention, and that order suppose is against you, then you also have a remedy.
Lordship, yes.
You have a remedy to come by way of a revision, appeal, whatever.
Lordship.
So that is that's the process, that's the procedure. So this court will not go into that aspect of the matter in this. See, as far as this appeal is concerned, as of now, the appeal will be admitted.
Lordship.
Appeal will be admitted. Matter will be heard. But as far as the execution or stay of the execution is concerned, I think you have to approach the execution court
Lordship.
and get, like I said, it's up to you.
Lordship.
Whatever order you get, then you can assail that order or comply with it.
Lordship.
Heard, Ms. General Counsel for the appellant, who has submitted that the appellant, being aggrieved and dissatisfied with the, where's the impugned order?
Lordship, impugned order is page number 74, Lordship, of the main appeal, Lordship.
In the stay application is page 12, Your Lordship. Page 11.
Okay, 74. Kunto. Common judgment and order dated 11/3/2022 passed in reference under bracket REF LA case number 108/2015 has approached this court with this instant application. It's an appeal. Where is your prayer?
My prayer is at page 71, Lordship.
71.
Lordship.
Your Lordship, here we are on stay. The prayer in the stay is page.
No. Stay, I'll pass a separate order.
Your Lordship.
This is on admission of the appeal. With a prayer inter alia to set aside and quash the said impugned order dated 11/3/2020. All the respondents are here.
Your Lordship.
There are 3 respondents arrayed in this appeal. Respondent number 1 and 2 being the state and the collector, and respondent 3 being the degree holder. All the respondents are represented through their respective counsel. As such, no formal notice is required to be issued in this regard. On admission of this appeal, the appellant is directed to prepare paperwork. List this matter after 2 weeks.
Lordship, the records may be called for, Lordship.
In the meantime, the records of the said LA case, reference LA case number 108, are hereby called for. Kanigere have to go Steve.
Your Lordship, if the records are called for, then to go to the trial court will be of no consequence, Lordship. If they have to approach for stay of the execution before the trial court, calling for records, Your Lordship, then
The records of the
main case is
main
called.
case and the execution case are tagged together,
No, Lordship, it is not tagged together.
or it goes.
It is separate, Lordship.
together.
That
It is
no.
together. The records are together.
No, Lordship, I have verified the Lordship. Lordship, I have verified. It is not tagged together.
Not tagged.
I have
More
verified.
often than not, I don't think so.
It is not tagged together, Lordship.
You see, execution case is a separate proceeding altogether.
Your Lordship.
Heard, Miss Counsel. For the petitioner who has submitted that on the related appeal being admitted, a prayer for stay of the execution of the decree passed in the said judgment and order dated 11/3/2020 is hereby prayed for. On the various grounds as detailed in the said in this application, at paragraph 3 under the heading I quote more grounds on which the decision and conclusion of the special judicial officer are challenged. However, Mr. P. Nongri, Land Counsel for the respondent number 3 at this point of time has interjected to say that there is no scope for stay of the execution proceeding in view of the provisions of Order 41, Rule 5 of the Code of Civil Procedure, particularly sub-rule. Is it sub-rule 4? It's only 2.
Sub-rule 1, 2 and 4, Lordship.
Sub-rule 1, 2 and 4.
And 4.
Where?
3C, Lordship, sorry, 3C.
We'll just confine to the power of the execution code. Where? I mean, I should take sub-rule. Where an alternative remedy is available to the judgment data to seek stay of the execution of the decree with relevant and appropriate prayer made before the execution court, which was not done so by the petitioner herein. On consideration of the submission made, this court is also inclined to agree with the submission of the learned counsel for the respondent 3, and therefore the prayer made in this petition is not allowed at this point of time. The petitioner may seek appropriate recourse before the competent court if so desired. Petition disposed of.
All right.
Lordship, regarding the security deposit, I am praying that
That will before the
Lordship, if it may be waived off, because in
So that security deposit, as far as the appeal is concerned, is not required.
yes,
It is
Lordship.
only in the execution.
Lordship. Much obliged, Lordship.
Item number 3.
My lord, this matter, if Lordship will recall, was heard twice. Just that, my lord, the charge sheet that was appended with the petition, my lord, some vital documents pertaining to the statements of the, my lord, accused and witnesses were missing. I have got a copy of that with me. Before I submit the same, my lord, my limited submission would be, my lord. Here there are 3 accused, my lord. Now the third accused is before your lordship by this petition, my lord. My lord, on the perusal of the statement of the very petitioner here, the accused, my lord, he has got a long checkered history of, my lord, being a hardcore member of a well-organized drug cartel, my lord. And he was the main supplier, and that apart, my lord, he is not involved only in this particular transaction, my lord. There are a number of, my lord, transactions which he himself has, my lord, revealed in his statement, that is fortified further by the statement of the other 2 co-accused, my lord. So I have got a very strong objection for his release on bail. I have marked the, my lord, highlighted and flag marked it.
Yes, Mr. Yada.
Lordship. Sir has made a reference to basically the statements made by the co-accused. Need not actually bring it before the court's consideration, but Your Honor probably can recall the judgment rendered in Tufan Singh's case, 2021 4 SCC 1. It can just be noted down. It very clearly stated that the statement given by co-accused persons are of no significance. They don't have evidential value unless corroborative evidence is gathered to support the statements made by the co-accused persons. Now that is lacking in this instant case, Your Lordship. I must take Your Lordship to the fact that 3 Caesar witnesses, out of 10 witnesses, 2 Caesar witnesses have been examined, and they have demolished the prosecution case, on account of which the co-accused was granted bail. I would like to take Your Honor to the order of bail passed in the co-accused person's bail application, which is at page 50 of the petition, Your Lordship. Page 50.
50.
50.
Yes.
So, starts from paragraph 18. The paragraphs before paragraph 18 basically are rephrasals of what I said and what the counsel for the respondent had said. So, paragraph 18, Lordship, will just start reading. This court has considered the submission for and against the grant of bail on behalf of the petitioner herein. Facts as stated above is that the petitioner was arrested in connection with an offence punishable under section 22C of the NDPS Act, which involves the possession of commercial quantity of psychotropic substances, the punishment of which shall not be less than 10 years. In such a situation, when a prayer is made for grant of bail, the provision of section 37 is retracted. Needless to say, for consideration of bail involving section 37 of the Act, the approach of the court is not to grant bail except on the ground that the court is satisfied that the reasonable grounds for believing that the accused is not guilty of such an offence. Para 20, Lordship. The rigors of section 37 invariably have prevented the court to grant bail to an accused if, in course of investigation or trial, nothing is presented in favor of such accused person to dispel the doubt or presumption that he is indeed guilty of such offence. Para 21. However, there are exceptions to this rule even if the provision of section 37 is applicable in a given case. One of such exception is the consideration for grant of bail if prolonged or unnecessary delay in the proceeding not attributable to the accused has been occasioned. The other is the aspect of reasonable grounds to believe that the accused is not guilty of such an offence. Then, Your Lordship, quotes a judgment rendered by the Apex Court in Shiv Keshri's case. I'll take you to the relevant paragraph, which is paragraph 11 of the said judgment, which is at page 52, Lordship. Let me just read it out. The court, while considering the application for bail with reference to section 37 of the Act, is not called upon to record a finding of not guilty. It is for the limited purpose essentially confined to the question of releasing the accused on bail that the court is called upon to see. If there are reasonable grounds for believing that the accused is not guilty and records his satisfaction about the existence of such grounds, but the court has not to consider the matter as if it is pronouncing a judgment of acquittal and recording a finding of not guilty. Coming back to the case in hand, what is observed is that the petitioner, having been arrested in the said case and undergoing trial, the stage of the trial is for recording of evidence, recording of the evidence of the prosecution witnesses, of which 3 out of 10 have been examined. The petitioner, taking note of the deposition of the 3 witnesses and finding that the statements made by these witnesses have for the moment failed to implicate the petitioner as far as possession of the alleged contraband is concerned, therefore he has approached this court with this petition seeking for grant of bail. That this court, even if the authority cited by the learned PP, that is the case of Vilas Pandurang Pawar, as also the proposition found in the case of Shiv Sankar Kesri, is taken into consideration, there is no reason to indulge in critical analysis of the evidence on record. As on a bare reading of the same, the evidence of PW2 and PW3, who are independent witnesses, Lordship, cleared the air that the petitioner cannot be linked to the discovery of the alleged contraband substance found in the tin box. Firstly, not from within the compound of the house of the petitioner, if at all, and secondly, certainly not from his physical possession or even his conscious possession. Lordship, the allegation in the FIR is that these 3 individuals had hid the contraband. Now, the Caesar witnesses came, demolished the Caesar, dented the prosecution case, on account of which the co-accused was released on bail. Now, at this juncture, I would also like to make a referral to paragraphs 18 and 19 of Muhammad Muslim's judgment. Your Lordship had also quoted the same in this particular order of yours, Lordship, in page 47 of the charge sheet. Page 47 of the petition. Page 47, Lordship. I believe they are quoted. Okay, I'll just read them out. I had relied on these, I'm relying on these again. Para 18 of judgment rendered in Muhammad Muslim's case. The conditions which courts have to be cognizant of are that there are reasonable grounds for believing that the accused is not guilty of such offence, and that he is not likely to commit any offence while on bail. What is meant by not guilty when all the evidence is not before the court? It can only be a prima facie determination that places the court's discretion within a very narrow margin. Given the mandate of the general law on bails, section 40, etc., which classify offences based on the gravity and instruct that certain serious crimes have to be dealt with differently while considering bail applications, the additional condition that the court should be satisfied that the accused, who is in law presumed to be innocent, is not guilty, has to be interpreted reasonably. Para 19, therefore, the only parameter in which such special conditions as enacted under section 37 can be considered within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the material on record whenever the bail application is made that the accused is not guilty. Any other interpretation would result in complete denial of bail to a person accused of offences such as those enacted under section 37 of the NDPS Act. Lordship, at this juncture, the accused person has been in custody for over 2 years, 2 months. At this juncture, what is before your honourable self, Lordship, are the deposition of the witnesses. The deposition of the witnesses have dented the prosecution case in as much as the prosecution and in as much as the Caesar procedures have absolutely been flushed down the gutter, also one would say, because they have given an interpretation of the police having had searched the residence on the night of the 30th of June. Thereafter, the police, finding nothing in the residence, stayed back in the residence and came back in the morning. Stayed back in the residence, and the witnesses were called the next morning. So the police officials staying back in the residence and calling the independent witnesses the next morning, and also starting the search before their arrival. Now, these things have shrouded the prosecution case with inconsistencies, Your Lordship, and of course, a big amount of doubt. And on these accords, Your Lordship, the co-accused was granted bail. Now, what do we have against the co-accused? Sir has read out statements. He has not read out statements, but he says that he has marked out certain paragraphs in the statements of the 161, from the 161 statements of the co-accused. Now, what do we have against that? Let me also inform the court that there is no call detail report on record, establishing the link between the persons who have already been granted bail and this particular individual. So, how do we ascertain that actually the facts which have been recorded in the 161 statements are true? In any case, 161 statements are not admissible, Lordship, as Your Honour is well aware. What do we have against those? Are there any corroborative evidence on record? No. Caesar witnesses have been examined, who have demolished the prosecution case. And if, Your Lordship, the Caesar is demolished, can an accused who is alleged to have been a part of the conspiracy can be held guilty at this particular moment when the bail application is being preferred in terms of paragraphs 18 and 19 of the Muhammad Muslim judgment? No, I say no. Hence, Your Lordship, I believe ground for grant of bail is made up.
Mr. Guru, is there anything in the CD where the accused being involved in some other related cases have been
My lord,
noted?
his very statement will reveal that, right, my lord.
Oh, his statement, again.
However, my lord, at the bail stage, my lord, that statement can be used, my lord, at the bail stage, though it may not be admissible during the trial. And that apart, my lord, what my learned friend has submitted, that two of the seizure witnesses has somehow dented the case of the prosecution, that doesn't hold any water. There are 10 witnesses, another 8 might establish the prosecution witness, my lord. It's the culmination of the trial, my lord.
Has any evidence been gathered against or in advance of what was stated by the accused lordship? Nothing at all. For 2 years, the accused person has been in custody. Nothing has been gathered in furtherance of whatever has been stated by them in the 160.
That will have to wait till the culmination of the trial.
No, but investigation is over. We have all relevant documents before ourselves. No prayer for further investigation.
What is the complete charge sheet? This one?
Lordship, the complete charge sheet is there from pages 27 to 40. All the findings are included in these particular pages, Your Lordship. The rest are annexures. From pages 24 to 41, Lordship. Not a whisper is mentioned about how the accused person is involved in other cases as suppressed. Nothing at all. Further, perusal of this charge sheet also shows that no CDR is on record, Your Lordship. All detailed report. The accused is only arrested on account of 161 made by the co-accused.
Mr. Guru, you said that, see, at the stage of bail, or for consideration of bail, the statement of the accused, or the co-accused for that matter, implicating them, prima facie, can be relied, at least for consideration of bail. You have authority on that?
Can be good. My lord, right now, maybe in the course of the day, half an hour, my lord.
See, because why?
At Bailey Street, it
Mr.
can be, my
Arab,
lord.
see,
Lordship.
his statement is very clear. He has implicated himself.
Exactly.
This, if you distinguish his role and the role of the other two accused,
They cannot be equated, my lord.
two different aspects altogether.
Cannot be held in tandem.
They have not been, see, they have not been linked. They have not been, found to have any connection with the seizure or, with the discovery of the consignment. But he has, at least he has given some clue as to how, the whole transaction transpired.
Exactly.
So,
Absolutely.
Lordship.
on that ground, I don't think you have.
Right.
But
Lordship,
only I would like to satisfy myself as to.
My lord, half an hour, my lord. I'll get.
I may also be.
I'll hand
You
it over.
can, if you get counter authority.
If you can have it at the end of the board, otherwise.
No, my lord. I'll just supply it in
Because
just
we need to
15-20
reply to the
minutes.
same.
I know.
Lordship, just two things for your
I'll,
honors.
I'll reserve this order.
My lord, deeply please.
Reserve what? You just get me those.
Lordship, just two things for your honors on facts, of course, which may have missed out. If you read the FIR, the source information was basically the source information as per the FIR. Basically,
That's the enough, whatever the case may be.
right.
Even if Section 37 is not applicable here,
Lordship.
let's say, generally on bail, the court has to be convinced. The court has to be convinced that he is not a flight risk, number one,
That, of course.
and that his antecedent has to be taken into account. Those are some of the factors or parameters with on the ground.
Universe.
Flight risk can be, of course, curtailed through.
He is linked to the consignment, whatever the case may be, directly, indirectly,
But in
whatever.
furtherance of that, Lordship, if there's
It
anything on
reveals
record,
that not only this case, he had been at it since a long time, my lord.
I'm dismissing your case. It depends on you
Deeply please.
how you do it.
Lordship, authorities, as your honor.
Please.
Daily list item number 1.
Yes. What is this?
My lord, this is an anticipatory bail application. On the last date, Lordship was pleased to call for the CD.
Oh,
May please, your lordship.
by the way, have you preferred,
Yes, before
Yes,
sessions.
that has been
Yes.
noted.
Yes.
yes, Mr.
Yes, Lordship. Lordship, we just received the CD, which is very bulky. I couldn't get a time to go through it, but then, Lordship, to make a quietus with this matter, Lordship, I received a status report also, which states that two of the applicants have already been arrested, and the third applicant is absconding. If I can produce the,
How many?
there are three applicants.
Three
in the-
applicants.
If they have been arrested, then
They have not been arrested, Lordship. What had happened after the CD was called for, Lordship? The police started to harass and threaten the clan members and the family members. In fact, the father of the petitioner number 1 has also been implicated, a 60-year-old person, Lordship. Under that circumstances, they had no other option to surrender. However, the petitioner number 3, Lordship, he's
that would change the
that changes,
complexion.
Lordship.
Then this petition.
Lordship, I would place some arguments only for the petitioner number 3 today, if Lordship
Lordship,
permits.
if it's a joint application, Lordship, matter becomes infructuous, let him withdraw matter and let him file fresh. Like,
Lordship,
that's my only submission, Lordship.
Yes, true.
Lordship, then I would withdraw it with the liberty to file.
Mr. Letter Counsel for the petitioner has submitted that on being instructed, this petition may be allowed to be withdrawn with liberty to file afresh. Mr. Iskar Wanlang, Letter Additional PP has no objection to the preamble. Accordingly, petition is hereby dismissed as withdrawn. Liberty sought for allowed.
Obliged.
Obliged.
Item number 2.
Lordship, regarding service of notice, I was informed that it was served yesterday, Lordship, but I have not received the service report yet. Oh, she's okay.
Well, it's,
Legally, 3 to
3 to 9, Lordship.
So how far have we progressed?
Lordship, item number 3, I have gone till the order of my dismissal, Lordship. That is at page 57.
This is 468.
Item number 3.
WPC 468.
468, yes, Lordship.
Dasnya dikali Yes.
So the order is at page 55, Lordship. The grounds of dismissal. Although the order was 21st September 2018, the petitioner has received the order on 14/11/2018 through post office.
1411.
14/11/2018.
This is the dismissal order.
Dismissal order, Lordship. These are the grounds.
Yes.
The grounds more or less the same as they have given in the show cause notice, Lordship.
Yes.
If I read the entire order, Lordship, the ground will be very vague and baseless. Whether this type of allegation can constitute a misconduct warranting the dismissal of a dismissal, Lordship. I'll just read paragraph 1. Misbehave with the parent and guardian, also with the principal cum secretary of the school. Very weak. When I have misbehaved, what is the charges? Denied to receive the official letters of the school. These are more or less same, Lordship. I'll just come to the operative part, Lordship.
Yes.
The operative part will be the page 57, Lordship.
Yes.
Last para, Lordship. On the premises above, it is held the good and sufficient reason that the continuance of Sri so-and-so assistant teacher in school in service is prima facie detrimental to the interest of school education and discipline of the school, and thereby in pursuance to the MC meeting resolution. My lord, this is very important. MC meeting resolution number 1 dated 30/10/2016. My LS misconduct is 2017-18, but the resolution for my termination was taken 2016 with the approval of the DSEO Tura by number so-and-so dated 4/11/2016 and instructed by the district school education officer Tura by number so-and-so. The service of so-and-so is hereby dismissed. Next page is the what is the resolution of 2016 as well as the approval order of 2016, Lordship. That is the approval order, Lordship. They have mentioned that order dated 4 November 2016. This is the approval. Next page. Next page.
Page
58, Lordship.
Okay.
This is by the busy moment to the principal camp secretary. That is why I am saying, Lordship, even 2000, the conspiracy or the plot to take action as against the teachers were taken way back in 2016, Lordship, in connivance with the SDSEO busy moment, DSEO busy moment. Now pay health up, subject kindly see, the pay health up of Garudubi so and so. This resolution also taken, this approval was taken behind the back of the petitioner. After that, the petitioner's salary, although half salary was giving, there was no dispute on it. But the subject was pay held up with regard to 4 teachers. 2 is terminated and 2 is suspended. As resolved by the managing committee of so-and-so, this resolution number dated so-and-so, which is duly approved by the undersigned dated so-and-so, you are hereby to held up the pay monthly salary of so-and-so, and further decision of the MC of the school. Further, you may suspend or terminate the above teachers which may deem fit and proper on drawing legal so-and-so, so cause if any so-and-so, discipline and illegal activities which are detrimental against the school without further approval of the concern. Can that type of order be issued by the official respondent, Lordship? He has to check. He has to see and whether the teachers of such school has been being victimized by at the hands of the that management or not. That is why some power is given just to maintain the check and balances. Now he has, without the thing he has given, that you can anytime you can terminate or suspend whatever you mean to take action against the concerned teacher. That also without any taking further approval. Now next page is the resolution of what they have, resolution 1-10-2016.
Page
is 59, Lordship. The resolution dated 30-10-2016. Why I am mentioning, Lordship? Because this resolution as well as the approval has been mentioned in the dismissal order.
yes.
Because as per section 9(2) of the Meghalaya Education Act, Lordship, the teacher cannot be terminated without due approval, without prior approval from the government. Now, my misconduct is 2017-18. Can he terminate relying on the approval which was sought for different purpose in the year 2016? This amounts to what? This amounts termination without approval. That is the violation of Rule 92 of the Meghalaya School Education. I will come later, Lordship. This is the resolution. This resolution talks about different thing. The misconduct of 2016, whatever may be. But that was also, we are not aware. No show cause, nothing. Behind the back of the teachers, the managing committee has taken the resolution and subsequently got approval from the SDSCO, Lordship. Now I will come to the inquiry, Lordship. My inquiry.
No, you have been terminated by this, that page 57.
57, yes, Lordship. Relying on the resolution of 2016 and approval of 2016. 57. And government has admitted, Lordship, in their counter in item number 2 that no prior approval was obtained. So I'll come to the counter filed by the state respondent in item number next the second item, Lordship. They have categorically admitted that it cannot be done. Now, that is another aspect of illegality in passing the impugn order because the prior approval was not sought. Now, apart from that, Lordship, now since they have said that some DP has been initiated against me, I would like to see the inquiry report. My lord will see page 36 of the counter affidavit filed by the respondent 4 and 5. Page number 36, Annex 10. The counter affidavit filed by the respondent 4 and 5. That is the principal cum secretary, Lordship.
Just a moment. This is affidavit dated 15/7/2019.
The Lordship, 18 April 2018, Lordship. 16 April 2018.
16 April.
Page 37.
No, I'm talking about the affidavit file.
Affidavit filed by Lordship. Yes, 15/7/2019.
Page 30.
36.
Four and 5. Respondent 4 and 5.
Yeah, 4 and 5, Lordship, yes. May I read, Lordship? This is the constitution of inquiry committee. Who are the members in the inquiry committee? My lord will be surprised.
Yes.
Now, the complainant is also the managing committee. The police is also the managing committee. The prosecution is also the managing committee, and the judge also the managing committee, Lordship.
Yes.
As per decision of the managing committee of Garodubi so-and-so by MC resolution number so-and-so dated 7/4/2018, which is duly approved by the district school education officer number dated 10/4/2018, the undersigned is pleased to form an inquiry panel to inquire into the allegation leveled against Sri Maqbul Hossain Sheikh, assistant teacher under suspension, then Sri Abdul Basit Sarkar, assistant teacher under suspension, by show cause notice dated so-and-so on behalf of the undersigned with the following members. Toyab Ali SMC member. See the members of the inquiry panel, Lordship. Abdul Azad Sheikh SMC member. Sri Amir Hossain vice principal. He is also teacher representative of the so-and-so of the school. The inquiry panel are requested to inquire the allegation leveled against the above two suspended teacher by explanation and show cause notice enclosed herewith, and submit the detailed report to the parent, to the President, Secretary, Managing Committee of Garodubi Higher Secondary School as early as possible, so that the disciplinary proceeding shall be drawn against the above suspended teachers in expedite. Now, explanation, I don't know, Lordship. What explanation? I am not aware. I have not received. Show cause notice. This is 10/4/2014, Lordship. That is 4-5 years back. That also I am not aware. Show cause notice dated 26/3/2018. That show cause notice I have received and I have responded. Now, we'll see the next page, Lordship. Next page is the covering letter of submission of inquiry report, Lordship. Garodubi dated 25 June 2018. Submission of detailed report of...
So,
this is the constitution.
This is the order for the inquiry
committee.
Okay. And this is the report. Where are the proceedings?
Below, Lordship. Next page, Lordship.
Okay. Page 38.
My lord.
Page 38.
Page 38, yes, Lordship. Why I am referring, Lordship, although there is a violation of statutory law, Lordship, but why I am referring all those proceedings in all, Lordship? Once you have taken the pain to draw a proceeding, Lordship, you have to follow the rules, how the DP is to be initiated and conducted and finalized the DP lordship. Now, primary thing, first you have to give a copy of the charge. In the charge lordship, list of witnesses.
You mean to say that procedure has not been followed?
Not followed. That is also yes, lordship. That is why. That apart from after inquiry, lordship, still they have to take permission from the government. Then only they can terminate. So, assuming that the allegation which they have leveled against the petitioner is true, it still does not constitute a misconduct, which warrant for the for dismissal, because this cannot be treated as a misconduct. This is a vague allegation saying that I have given a document you refuse to accept. I have given. I wanted to make some salary, but you refuse to accept. This cannot be. Now, lordship will see the inquiry report, lordship. I'll just read out the one by one. Members of the operative part. Members of the inquiry panel inform the students, parents, guardian, principal, Sri Mokbul so and so.
You are reading page?
Page 38, lordship.
38.
The inquiry has, as per their statement, the inquiry was held 3 days. 3 days. Date of inquiry 22/5/2018, then 4/6 of lordship. 4/6/2018, then 22/26/2018.
Yes.
Members of the inquiry panel informed the students, parent, guardian, principal, Sri so-and-so, suspended teacher of Garudubi Higher Secondary School in different occasions prior to different inquiry date to present in the school to verify the allegation framed against the above suspended teacher by explanation dated so-and-so. These are all prior to the, and I am not aware of those documents, lordship, and I was not given anything. The student parents, and who are the students, who are the parents, their name is not reflected here. This is just a vague and very frivolous allegation. The students, parent, guardian, and the principal of the school had cooperated with the inquiry panel but Sri so-and-so and Sri so-and-so of the school did not cooperate with the inquiry panel, had not added to the school on the date of inquiry. I am not aware. Neither any notice was given asking me, yes, we are going to conduct any inquiry, be present on that particular day. These are the witnesses are coming. No. Then how I am supposed to know that inquiry is going to be launched against me on that particular date? I am not aware. Now, lordship will see finding. Finding about the allegation by explanation dated so-and-so, 22/8/2016 against...
This explanation was given by whom?
This is the explanation they have given.
Not by you?
No, not by me. Not by me. Because I was not aware of this 22/8/2016 letter. That with regard to paragraph 1 in the allegation that made Sri against so-and-so, we have verified and examined some students of the school during the course of the inquiry by approaching them in person in the school premises and found that the grievances are true, genuine, and the delinquent teachers are found irregular in school duties and very much negligence in taking classes. Further, they have threatened the students who raised complaint over the illegal activities of the said teacher. Now, who are the teachers and who are the students? That with regard to the allegation in made para 2 by explanation dated 22 August 2018. I am not aware, lordship, that explanation. It is found that there is a verbal warning that has been given by the principal to the school, to the teacher, for which we could not find any concrete material fact, and hence the allegation is acquitted. With regard to the allegation made in para 3, the contention of complaint dated 16/8/2016. 16/8/2016 is verified by us on examining the complaint parents and guardians of the school by approaching them in person in there and found that some concerned parents and guardian had been misbehaved by the teacher in the school premises, where they approached them in the school for requesting them to be regular in their school duties. Now findings about the allegation by show cause notice dated 10/4/2017 against Sri So-and-so. That with regard to the allegation framed against Sri So-and-so, we found that Sri So-and-so was become the group leader of other teacher. That is also the allegation, and brought them to Tura on 7/4/2017 to lodge the false complaint against the principal cum secretary of the school without any casual leave granted to them by the school authorities, for which the innocent students of the had lost the education. Further, he is found most disobedient and disciplined employee of the school. That is also because in 2017, Lordship, we lost 2 complaints before the DSEO, saying that highlighting the conduct and the misappropriation done by the principal. That also he accusation that I am the group leader and I have taken all the teachers to the DSEO Tura for lodging complaint against the principal. That is also another allegation. Finding about the allegation by show cause 26/3/2018 against Sri So-and-so. That Sri So-and-so was denied to receive. My lord, these are the content of the show cause letter 26/3/2018. That Sri was denied to receive the explanation letter by memo number so-and-so from the now 22/8/2016. Now in 2018, principal is saying that I have refused to receive the letter of 2016. That is also another indiscipline. Namely, so and even also refused to the receipt of the said letter from the post office. Hence, the allegation made in para 1 of the show cause notice dated so-and-so is found by us as true and proper verification of records of the school. That with regard to the allegation made in para 2 of the show cause notice dated so-and-so, it is observed by us that allegation is found true and as per documentary evidence available. Now, my lord, they have verified the document of the school, but they have not verified my statement. I was not there. We can say this is expertise. These are all fake and baseless allegations put against me. Now, next page, Lordship, operative part, Lordship.
Yes.
This neither I was given any show cause notice nor any charge memo was given to me showing that these are the witnesses, these are the documents you are going to relight and you be present on so and so that we are going to conduct an inquiry. No such evidence. This is, we can say that conclusion part, Lordship, that we have examined the student of class 9 of the school and asked them about the fact of snatching of question paper of class 11 promotion examination 2018 supplied by the emboss on 5/2/2018 during examination period by Sri Mokbul Hussain Sheikh along with other teachers from the vice principal of the school, namely Amir Hussain Sarkar. And he is also one of the inquiry member, Lordship. He is also one of the inquiry member, the Amir Hussain Sarkar. And the allegation is that I have snatched some question paper from the hands of Amir Hussain Sarkar. And on query, they replied in positive that the fact was exactly happened as alleged in the show cause notice 26/3/2018 by para number so-and-so. Further, the student stated that Sri Mokbul Hussain Sheikh threatened Sri Amir Hussain Sarkar, vice principal, of dire consequences if they held the examination in front of them. Then Sri Mokbul Hussain Sheikh dispersed the student by force from the examination hall before the examination period time is over and had called the police to arrest the vice principal and other teachers who were engaged in the examination duty. Thereafter, he lodged a false FIR with the police leveling the charge of attempt to rape a lady teacher, namely Sri So-and-so, against the vice principal and other teaching and non-teaching staff of the school. The students were the eyewitnesses that Srimati So-and-so was standing on the veranda of the school and was not entering into the examination hall, and no attack was made by anybody else to attempt her rape. Hence, we prove and held that the allegation made so-and-so of the show cause notice against the so-and-so is found true. That is the allegation of snatching away from the question paper from Vice Principal. The allegation made in para 8 of the show cause notice dated so-and-so is found true, that Sri Mobulation has allowed to unknown Garo boy who was not the student of Garo Dubi Higher Secondary School after so-and-so to last examination to sit in the examination without admission into the school and registration of embossed so-and-so. We have checked and verified the admission register and students attendance register of the school and have not found the record of admission of such unknown boy in class 11. Therefore, we are in view that there are grave allegations against Sri so-and-so, who is ultimately proved as true and held guilty of such allegation of charges. They have.
Yes.
The inquiry panel found that I am guilty of misconduct, and I don't know what misconduct we have done, Lordship. Now I'll just read my one additional affidavit, Lordship. One additional affidavit.
Where's your rejoinder to this?
I have filed my rejoinder, Lordship.
Then what do you say about this?
I have denied that everything done behind my back, Lordship. My Lord will find the rejoinder. I have given the rejoinder to the entire counter affidavit filed by the respondent number 4 and 5. I simply said that I was not given the notice, I was not aware, everything was done behind my back.
Yes.
I have responded, Lordship. Now one rejoinder, Lordship, that additional affidavit I have filed because one Blazers has filed a Lokayukta case before the Meghalaya Lokayukta alleging misappropriation of funds by the principal and his brothers. So the Lokayukta, that inquiry wing, Lordship,
Yes.
has conducted an inquiry and submitted the report to the Lokayukta, and after that, Lordship, then FIR was lodged against the principal and his brother. He was arrested and subsequently he was released on bail. Now there are 3 criminal petition, Lordship, pending. The principal has filed 482 application before this honorable court,
Okay.
and that is still pending, Lordship. I'll just quickly read out the operative part of the inquiry committee of the Lokayukta, Lordship. How influences this person? He can threaten the staff also, government officials, officer also.
Okay.
This was filed in 2022, Lordship. That affidavit bring on record 6/4/2022.
Yes.
My Lord will find page 5. There are 3 annexures. Page 5. This Lokayukta case was filed one of the Blazers.
Yes.
The inquiry officer also has gone through the entire reports or inquiry report or inquiry conducted by the DC Lordship, 5 or 7 members in 2017. He has highlighted, apart from that Lordship, my Lord will find page 8. I'll just read out the statement of the principal.
Okay.
Page 8
Of this affidavit.
of this affidavit, Lordship. My Lord
Yes.
got it,
Yes.
because the others are the statement of the teachers, Lordship. Why I am not referring? Others are the teachers of the statement of all the teachers here. How they have victimized, they have reiterating the same. That, so that is why I am not referring to that. Paragraph 6, Lordship. I.S. Chaudhary, that is the principal cum secretary. As it about so-and-so principal cum secretary Garudubi Higher Secondary School, he was the principal of the Garudubi School and also functioned as the secretary managing committee. He has been the principal of the school since its inception. He denied all the allegations brought against him by the teachers. He simply said that he has been functioning in the interest of the school and the student as a whole, as empowered by the managing committee. He flatly refused to produce all the registers. My Lord, he flatly refused to produce all the registers along with all the payment of teachers' salary. Instead of producing the documents, he threatened to go to the High Court.
Yes.
Now, if you are clean that you have not misappropriated the money, you should have given the register to the inquiry wing. This is an independent body. He refused to cooperate with the inquiry. He categorically admitted that he was drawing double salary, one for the principal post and the other is teachers. On inquiry about a ghost teacher by the same name, Samuel Islam, whose pay is being drawn by every month, he stated that there is a teacher by the name of so-and-so. Now, Busy Momir, this is the DSEO.
Yes.
Because the entire thing was happened because of him. He is also partially liable for all those incidents. Busy Moment, the retired DSEO, was also examined in connection with the reconstitution of School Managing Committee, which was suspended by Sri S.K. Shah, retired DSEO, his predecessor, over the recommendation of the inquiry committee constituted by Provin Bokshi IS, the then DCO of the West Garo Hills, on financial irregularities and arbitrary functioning of the managing committee. He said that he has acted within the powers of DSEO to restore the managing committee according to guidelines. However, he did not follow the guidelines for video recording of public participation in the meeting for restoration of the managing committee. He also said that there was no follow-up action from his department to recover the alleged misappropriation of funds. Now, P. Ringshai, he is also DSEO, and his staff have produced all documents relating to his case. Srimati C.J. Sangma, present DSEO, was hospitalized and preceded on leave. Srimati G.D. Sangma had also retired 3 years earlier. As per the statement of present DSEO, Sri P. Ringshai, he has requested the Director Local Funds Shillong to conduct an special audit in respect of Garudubi Higher Secondary School by letter dated so-and-so. It is reported that the incumbent principal, Sri Islam Haq Chaudhary, refused to cooperate and rather threatened the audit party who were unable to complete the audit of the school.
Yes.
Because when this was surfaced, then from the department they initiated the process for audit. Now he threatened the government officials and he obstructed for auditing, and he on his own, without the approval of the government, and on his own he has conducted an audit saying that yes, I am clean, no allegation against me. Now conclusion, having recorded the statement, a prima facie case seems to exist against the incumbent principal comes on. So this is then after that my Lord Lokayukta has directed for registration of FIR. Then DSEO has lost an FIR against the principal. He was that is matter. Why I am showing Lordship how influences he is, and the person who can threaten the government officials can, a simple teachers like the petitioner, threaten and obstruct all this functioning of the managing committee cannot.
Yes.
Now, Lordship, the law points. Now, whether it will take time, Lordship.
Why?
Then we can.
So we'll continue tomorrow.
Tomorrow also, no problem, Lordship. That will be better, Lordship. Subject to Lordship convenience. Because item number 3 and 4 is identical. In item number 2, I'll not take much time, Lordship, because the only event page also same.
Okay.
Acquisition is also same. Still, I'll just. So tomorrow at least item number 3 and 4 we can complete, and I can argue on law points, Lordship, because there are 3 basic arguments, Lordship. Whether the termination was as per law, whether prior approval obtained. That is the main grounds, and whether the allegation put against me even say that they are true also, that constitute misconduct, which warrant dismissal from service. That are.
Or Mr. SSC, Grand Counsel for the petitioner. Argument is not concluded and will continue on the next date fix and will continue tomorrow as prayed for by the Grand Counsel. List accordingly. Moreover,
Item number 10.
Yes, my learned singers come on.
Because there are 4 repetitions altogether. So, 3, if I believe.
4, 2 or 4? Only 2.
But there are, because item 10 and 11. These are 2 analogous matters, out of the concerning the same. In item 10 there are 2 repetitions, and item 11 there are 2 repetitions.
But why are they? Why are they tagged together?
This is regarding that forest colony area.
Notice.
Yes.
A similar notice was issued to all the petitioners.
Oh, vacating the premise. That is the case.
Yes, in spite of no stay order, they have not been, that notice has not been acted upon.
Yes,
No. In fact, I think this is the 3rd notices which they have received. This has been going on for the past 30 years. Notices have been issued and then they sit over it.
So you're not interested. If you're not interested to pursue the matter, then you should concede.
No, my lord, it cannot be considered.
Then?
My lord, that is exactly why we have taken up the matter.
Yes, sir. You can start.
My lord recalls, my lord, that day my friend had started the argument with the advance argument on WBC 423 of 2019. So thereafter, my lord, I had advanced my part of the argument. To sum it up.
Yes.
But I was only praying if my learned senior could start today. I'll supplement him at the end, but there's no need for rebutting, because his argument would more or less be the same in respect of.
My lord, on the last occasion when the matter was taken up, Lord, my friend has advanced his argument. Thereafter, I had placed my argument before this honorable court.
If you
Have you completed your? Have you completed?
I have not, my lord.
In
We
fact,
have to rebut.
In fact, my friend had completed. Thereafter, I started my argument.
Oh, okay.
If you also wish to hear it afresh, my lord, in that case, my lord, I would pray to have it next week.
Why?
or maybe tomorrow, subject to your lordship's convenience. We can have it next week, my lord. I'll restart again just to refresh your lordship of what we had argued on the last date. Are you there?
Just to refresh Lordship's memory, Lord, this is, my Lord, concerning the lease, my Lord, which has expired long back in the year 1988.
No, 50 something.
1988.
81, no, 81, 82.
No, my Lord, last date was 1988. Thereafter, it was never renewed. In fact, my Lord, prior to the expiry of the lease, there was a clear notice from the Forest Department to all the occupants, saying that there will be no further extension of such lease. This is the whole issue, my Lord.
The only thing, my lord, I think we are all missing the point. Here, my lord, after the lease was granted to me, my lord, it was for a certain period of time. That period lapsed. After that, my lord, it was again renewed for a certain other periods. Thereafter, my lord, that period also expired. Then I made an application for renewal, extension of the lease. That was not done, my lord. That was not done, and we approached this Honorable Court. The Honorable Court said, okay, you go and file a detailed application before the concerned authority, which we did. After that, my lord, an order came to be passed from the concerned officer. There, my lord, they say that the entire area is a reserve forest. Therefore, in view of Godavarman, my lord, we cannot extend the lease. Now again, my lord, if that be the case, we will be strict to, we'll be confined to only one position. If at all it is a reserve forest, then there has to be a notification under section 14 of the Forest Act, declaring the particular area as a reserve forest. That they have not brought on record on any occasion before this Honorable Court. In substance, and there are other issues also, my lord.
My Lord, petitioners, while approaching this Honorable Court,
Whether the issue of bona fide requirement would come in the picture.
no, there is no question.
No,
the Honorable Supreme Court is very clear on
why
that.
they rejected my representation was, my lord, that isn't reserve forest.
No, that's not the case.
No,
My Lord,
that is the case, my lord.
question of considering representation does not even arise. Firstly, my Lord, there is a clear notice by the government prior to the expiry of the lease that there shall be no extension of the lease.
No, my lord,
That
there has to be
representation is redundant.
if they
It will be of no
if
use.
They say, my lord,
No
it
practical
cannot be
purpose.
extended. There has to be some reasoning given. There has to be some reason as to why it cannot be extended.
That
And the
is
reason
precisely-
the reason that they gave precisely was that it is a reserve forest now.
My Lord,
But
precisely
therefore, my lord,
that
the
is.
section 14 will come into play. If you are
Section 14
declaring
will
it
not
as
come into play.
reserve forest, appropriate notification from the government has to be there.
My Lord,
The court will hear you wrong.
because their representation was
My lord,
also
kindly,
duly
since we are
considered
not
and
hearing
rejected.
this matter today, my lord, I was only praying if this could be fixed next week, my lord. I'll bring in all, since it's been quite some time has already lapsed since the day my lord had heard this matter. I was only praying, my lord, if this matter could be heard next week, my lord. We can put a quietus to this, my lord.
On condition, my
Subject to
Lord,
your
my
lordship's convenience.
friend will seek no further adjournment.
No question, my lord. In fact, I have already argued on the last date.
This has gone on long enough.
If I may, the Lordship will look at the affidavit filed by the government. Now, the stand of the government is that the notice has been issued under Rule 2, Sub-Rule 3 of the Meghalaya Forest Ejectment of Unauthorized from Reserve Forest Rules 1973. So, the specific stand of the government is that we have issued this notice under this particular rules. Now, under the rules, only a reserve forest. If it is a reserve forest, then a notice can be issued. Now we are here challenging the legality of that notice. This is a specific stand of the government that these notices were issued as per these rules.
My Lord,
I'll bring the rules.
my Lord, firstly, the petitioners will have to establish their right, my Lord. Then all that will come to
The writ
question.
court will not look into the rights of the parties. We are challenging here the notice, whether the notice is legal or not. That is all.
Yes. If
I have beg to
let's
differ, my lord.
see, the court has not heard. You see,
This is their affidavit.
the court has not heard the.
Nevertheless,
you see,
but
matter,
the
the
with
court
the
has not
coming
heard
of
the
the
matter in its entirety.
My lord, with
But
the
if what Mr. Dingro says that they are challenging the notice, then if that goes, you are free to issue a fresh notice.
my lord, they have to have, my lord, if before coming to this honorable court, they have to prove they show their locals, my lords. Who are they? Strangers cannot approach this honorable court.
We are
my
not
lords.
strangers.
And why did they issue notices to us then?
We are in a
If that's the case.
No, my lord, they were in occupation, my lords. They are illegal occupants, my lords.
next week any date more. Any day.
On pre-made by Mr. Estapal and counsel for the petitioner seeking accommodation. That is adjourned. Let's see after 1 week.
Obliged, my lords.
Item number 11.
Same.
10 and 11 are
Same order.
May I please your lordships? Lordships, I would like to make a mention memo. I would like to make a mention memo, your lordship. It's a criminal appeal, and the matter had come up on the 2nd of this month. And your lordship and our acting chief was in the bench, and had issued an order that the moment the LCR is called, the matter may be listed. The LCR is in the court, so it may be listed. Allow me to.
For criminal appeal?
Criminal appeal, Your Honor.
Once LC record comes, what happens is perhaps it's for preparation of a paper book.
Yeah, that's like if it could be fixed up on the 16th of this month. And
it would be for preparation of paper book.
yes, yes.
What is the order? What is the order pass?
That the matter may be listed as soon as the LCR is in the court. LCR is called for.
So the matter will be listed by the registry. Why is there the need
there's
for?
a bail application also pending. If that could be heard, that is urgency, Your Lordship.
See, that will come in due course.
Lordship.
Once such direction is given, LC record come, the registry will immediately post the case on the next available date. That's all.
Lordship, yes, that is true.
You
That
wait
is
for
true.
that.
But the urgency here is because he's in custody, and recently his grandmother also expired. He could not attend the last rites of the grandmother.
That will have to be looked into. So at least what you can do is you can talk to the registry and see.
We went there yesterday also, and they asked us to mention in the court. That's why we are before your Lordship.
Yes, because I don't think it will be proper. Yes. No. It's criminal. Oh, okay. Oh, that's what I said. Let the matter come next week, because see, previously we don't know what will be the roster of the court.
Absolutely.
So now perhaps a new notification will come, and thereafter we will know, how the matter will be fitted in.
Okay, because
so that will be the duty of the.
For a similar matter is pending today. First item is today on the same case. That is also pending today.
We can see if not, then we'll pose it to the next date when the other matter is listed.
Okay, if it could come up on the 16th, if your Lordship can accommodate us. 16th of next.
We don't know. 16 dates we cannot give. Because this court will not be sit on every day.
True.
If it is so, then it may sit twice a week, thrice a week, or we don't know. So we'll see. Mr. Nath, let it come in due course.
Lordship.
Just a matter of 1 week, so why would you worry?
Yes.
I have a similar prayer for listing of one writ appeal tomorrow, my lord. There's a slight urgency in the matter.
There's no bench tomorrow. No, there's bench not sitting tomorrow.
You can have it on Monday, my lord.
We don't know Monday. Like I said, okay, you make your mention. Next available date, it may be.
But if it is there on Monday, my lord, if provided it is there, the matter has already been filed.
If it is filed, then it will be listed. You just inquire from the registry.
We'll do that. All right.
Please, Your Lordship. Lordship, I beg to mention item number 5, Lordship.
Yes.
Lordship, the learned RFK General is leading this matter, Lordship, and he's on legs before the learned Honorable Apex Court, Lordship. The matter may be adjourned for the day, Lordship. Lordship, for 2 weeks. Possibly. For 2 weeks, possibly, Lordship.
2 weeks? Who's the other side?
I'm there.
5 to 19.
5 to 19. Well, if this matter, you're asking for 2 weeks.
Yes.
Then in that case, let this matter come up after the puja break. The many connected items. Yes. There are
connected items.
This is the matter relating to the Fifth Pay Commission.
You are appearing in all matters?
I am in the first matter.
What
in the
about
first matter, and Mr. Nongri is there in the other matters. It is a common judgment.
Yes.
The common question of law was involved, and it was decided by a common judgment.
Okay, 3 weeks then. That'll take us after vacation.
After vacation, yeah. Obliged.
On premier by Mr. H. Karanong, the additional CA seeking accommodation. That is adjourned. Mr. K.C. Gautam, letter counsel for the respondent is present. As agreed to by the parties, list is matter up to 3 weeks.
Obliged.
Is not declaring all the matters.
He said, nobody is.
For daily
So
list,
just a moment. This will be applicable to 5 to
5 to 19, Lordship.
5.
Item 5 to 19.
5 to 19. Huh? Same order.
Starts with state versus any Wellstar and hence the last item, Deva Prasad.
For item number 5 more. Okay.
6, right? No, 4.
Fine.
So you're there for 6, right?
No, I am there in all the matters, but in fact, this is the ruling matter. This is the lead matter for that.
daily list item number 1.
matter has, in fact, nothing survives in the matter, my lord, because the pension and other terminal benefits has all been released to the respondent, my lord.
What is the appeal against?
Actually, I have come against the order of the learned single bench.
Non-receipt of pension?
That instruction I have not received. I will just get an instruction whether it is correct or not. Then
No, actually, my lord.
no, Lordship, after clarification, I will withdraw it. But now, maybe I cannot simply say without any document.
Mr. P.T. Samuel, counsel for the appellant, has sought for accommodation. You give a copy.
Supply the copy.
Tomorrow. To seek necessary instruction from his client. Ms. Pasa, counsel for the respondent number 7, has submitted that she is entering appearance on behalf of the respondent number 7. However, a copy of the appeal memo has not been furnished to her, to which the counsel for the appellant has assured that the same will be supplied in course of the day.
Lordship.
On premium, this is matter to 2 weeks.
Lordship.
Hello, gentlemen.
Item number 3.
Please, Your Lordship, we have to file our objection.
My lord, this is an appeal against acquittal, my lord. I filed an application seeking leave to appeal, my lord, under section 378(4), my lord, because the appeal has been filed by the legal representative of the complainant. So to that application, they have filed an challenging the mental ability. They filed an objection, my lord. So I may be allowed to file a response to their application, objection, my lord.
Is an appeal by?
Appeal by the legal representative of the complainant, my lord. The complainant has passed away.
Can legal representative file an appeal?
My lord.
Complainant has passed away?
My lord, complainant has passed away, my lord.
Then the appellant should come within the definition of victim.
My lord. Then if it comes under the definition of victim, my lord, then the legal representative of the.
Now the second question comes. If you come within the definition of victim, whether leave is required or not.
Under 378(4), it is.
The apex court judgment is there.
My lord.
Please say objection.
Okay, you file your.
My lord, we file.
There may not be a requirement of leave also.
My lord.
Yes. That's what my brother has said.
I have also gone through some judgments, my lord, where victim.
See, there is a recent judgment.
My lord.
Judgment is there. It may not have been reported, but you just see.
Blessed.
Probably this year. It has been surrendered this year.
Blessed.
All the parties are in attendance?
Yes. My lord. Yes.
Mr. Learned counsel for the respondent number
1.
Respondent number 1
has submitted that the objection to the application filed by the appellant seeking leave while the appeal has been filed. Ms. Ardata, Learned legal aid counsel, appearing for the appellant, has submitted that sometime will be allowed to respond to the said objection.
Respondent number 2 is not filed.
Not required. Accordingly, as prayed for. Prayer is allowed. This is matter after 2 weeks.
Much obliged.
Item number 4.